Okay, so last week we began to study the issue of civil wrongs and tort law, the law of civil liability, and I presented to you the intentional tort category, and we began with the negligent tort category. The first question to ask in any situation where case law is discussed, tort law is discussed, is first of all the existence of a duty of care between the tortfeasor and the victim. Secondly, the existence of a breach of this duty, and lastly, the causation, that means the connection between the two. Considering the issue of determination of the existence of a duty of care, one of the main characteristics of this examination, the standard that has to be assessed by the court, is whether or not the damage was foreseeable by the tortfeasor. Could the tortfeasor have anticipated the consequences of the act so as to adapt his or her behavior? So foreseeability is a key criterion. Is the damage foreseeable? And where the damage is foreseeable, then there is a probability that the court will consider that there is a duty of care between the two parties. I stopped with the last case, Eor, Boyle and Young. Remember the case with this young woman who has suffered a nervous shock and fell down after passing by a place where a car accident has occurred, and the court considered that the negligent car driver could not have anticipated the damage that woman has suffered. In addition to the foreseeability criterion, there are two other criteria that can be pointed out. These criteria are, for academics, considered as shield criteria. Indeed, these two criteria, the one that I will expose to you right now, have been introduced in order to restrict liability. That means to restrict the analysis leading to the conclusion that a duty of care is existing between the parties. So that's why these two last criteria are analyzed as a shield criterion in order to restrict liability. First of all, the relationship between the party must have a proximate character. Indeed, for a duty of care to exist between two persons, there must be in a proximate relationship. That means that they must be, to a certain degree, connected the one to the other. In the leading case on this issue, the car power industry case, the liability of the accountant who made an audit of a society, of a company, the liability of an accountant who made an audit in a company was rejected by the court, considering the lack of proximity the accountant had with the subsequent shareholders of the company. That man as an accountant, has made an audit of the company, and he was negligent in the audit he made. After that audit, some person bought some shares in the company, but it seems that they made not a pretty good deal, and they sought to establish the liability of the accountant who was negligent in the audit he made. And the court considered in that case that there was no duty of care on the head of the accountant regarding the shareholders, considering the lack of proximity between them. They were not connected in no manner at all. There was no connection between those two persons. Therefore, there was no possibility to consider that the duty of care was existing between the two. So, in order for a duty of care to exist, parties must be in a proximate relationship, and lack of proximity comes to restrict liability on the head of the, let's say, supposed tortfeasor. Last criterion is the reasonableness of this duty. Indeed, the court must be satisfied that it is fair and reasonable that the law should impose a duty of care on the head of one party to the benefit of the other. That's another shield criterion. The court must be satisfied that it is fair and reasonable to hold that the duty of care exists in this particular set of relationship. And this lack of fairness or lack of reasonableness comes to limit, once again, the existence of a duty of care between two persons. Why this last criterion has been established? So as to not to overburden one person. Indeed, this, you must have in mind the way case law is ruling English law, and the mechanism of precedent has a very great importance. If in one case, in one particular set of facts, a superior court held that a duty of care exists in this particular relationship, because of the mechanism of precedent, anytime two persons will be involved in the same nature of relationship, they will be submitted to this duty of care. That's the mechanism of precedent that is applying in this here. Because of the precedent, if the superior courts held that in this particular situation, that person owes a duty of care to the other one, in the same circumstances, for the future, the court will be compelled to hold that a duty of care does exist. And sometimes it's difficult to infer from a set of facts a general principle, such as the existence of a duty of care in this particular set of relationship. That's why the court have the possibility to decide that no duty of care is existing between the two parties, where it is unfair to decide that way, or that it is unreasonable to hold that a duty of care does exist, because it would be a too heavy burden for one of the parties in a particular set of relationship. It would be disproportionate to impose a duty of care on the head of one or the other person. So the two last criterion, the proximity relationship and the fairness or reasonableness, are considered as show criterion that are applied to restrict liability, to restrict the existence of a duty of care in a set of relationship. The leading criterion is the one of foreseeability. Is the damage foreseeable in this particular set of relationship, and could the tortfeasor have the possibility to anticipate the damage? That's the key criterion. Additionally, the court will assess if parties are connected together and how, to what degree they are connected, and in the end, the court will assess whether it is fair or not to impose a duty of care on the head of one of the party to the benefit of the other. Is that clear for you, the legal criteria that have to be assessed by the court, and how these three criteria are connected together? The main one is the foreseeability criterion. The two other ones are analyzed by academics as shield criterion that comes to limit liability. Indeed, the court has never defined what is proximity. What is proximity between two parties? You find no case law ruling that. But you find case law exposing that in one particular situation, those two parties were not interacting in a proximate way, and the lack of proximity is established. But you have no positive definition of what is proximity in a relationship. So for this first criterion, is that fine for you? Once the duty of care has been established, the court has to assess the existence of a breach of this duty of care. The breach of the duty of care is scrutinized by reference. The breach of the duty of care is scrutinized by reference to an action or an omission, that a prudent and reasonable man won't have done. It is an objective standard of care. The legal standard is the one of the reasonable man, the reasonable person, the person who is behaving reasonably and prudently and who has made everything to avoid any injury following his or her action. So this analysis of the existence of a breach of the duty of care is made with reference to an objective standard of care, the one of the reasonable man, the one of the reasonable person. The breach of the duty of care can have two shapes. First shape, the negligent person has acted, has made a positive action, but has failed to take appropriate precaution. So that person has made a positive action, but without care, without sufficient or appropriate precaution. That person has acted with lack of care. So a positive action that has been performed by one person with lack of care, that person has failed to take all the appropriate precaution when he or she has acted. The second shape of negligence is the situation where the negligent person did not take any action in order to prevent the damage to occur. There has been no action at all. That person remained totally passive in the circumstances. So the second shape of negligence is the situation where that person did not take any action so as to prevent the damage to occur. And in this last shape, in this last set of facts, case law has discussed the question about to know where in some particular circumstances one person should be in the situation to behave positively, to make a positive action. Case law discussed the question about to know if in some particular set of facts some person should be imposed to act in order to prevent someone else's harm. Is there some particular circumstances where one person is compelled to act, to do a positive action so as to prevent the harm caused to one another? And in the end, case law said the following position is that such a duty to act is not a possibility as a general principle. It is not possible, it is not fair, it's not reasonable to impose a duty to act to one person, except in some particular circumstances. And case law has specially defined the situation where one person is compelled to do a positive action in order to prevent a damage to occur. So as a general principle, there is no duty to act imposed on the head of one person so as to prevent a damage to occur, but in some particular circumstances, such a duty may be established. But these are always exception to the principle, and the category of relationship where such a duty to act has been imposed is clearly defined by case law on a case-by-case basis. So, from case law, it's possible to settle the following category. First of all, where the defendant has clearly undertaken to protect the claimant. Indeed, there is an undertaking protection. I will do anything to prevent any harm to occur. Whatever the nature of the relationship is, the defendant to the tort law claim has promised or has undertaken to protect the other, or to take appropriate precaution for the prevention of any harm to the defendant. So first exception, where indeed a duty to act is imposed on the head of the tortfeasor, the situation where the defendant has undertaken to protect the other one. The second exception that is highlighted by case law is the situation where the defendant and the claimant are related together by a special relationship, where the defendant and the claimant are related together by a special relationship, for example, master and servant, the employer-employee, parent and child, any person who is in charge of another one because of the particular nature of the relationship or because of the job he is doing, that person has a duty to act in order to prevent any harm to occur to the person he or she is in charge of. So the particular nature of the relationship in this case imposes a duty of care on the head of the person who is in charge of another one. So even though there is no formal undertaking to take care, the nature of the relationship makes it obvious that there is a duty imposed on the head of the person in charge of another one to make anything possible to prevent harm to occur. The third exception is the situation where the defendant has a power of control over the third party or over the person who is at the origin of the damage, where the defendant has a power of control over the, let's say, the thing or the person who has caused the damage. That's the case law related to vicarious liability of parents regarding the torturous act of their children. Parents have a power of control and therefore they have a duty to act so as to prevent their children to commit any wrong. Also, you find in this exception the case law related to the damage caused by animals, dog or whatever. The master of the animal has a power of control and as such has the duty to take any positive action so as to prevent that animal to injure anyone else. And the fourth exception is connected with the third one, is where the defendant has a power of control over dangerous things. Indeed, some things are of dangerous nature, I don't know, explosive or whatever, chemistry or chemical products sometimes, where the defendant has a power of control over this dangerous thing, who, because of their internal composition, can damage or injure someone else. It is on the head of the person who has a power of control to take any positive action to prevent any harm to occur. So, case law settled 4 exceptions to the general principle according to which there is no duty to act, no duty to take any positive action, except where there is an undertaking of protection, where the nature of the relationship make it obvious that that person is in charge of another one, or where the person has a power of control over animals, over any other person or things that could be at the origin of the damage. So, in those 4 situations, the breach of the duty of care is established where the lack of any positive action is proved. It is sufficient to prove that the person did not act, did not take any positive act, did not make, any positive act so as to prevent the damage to occur. So it is, let's say, more easy to prove that the tortfeasor has breached his or her duty of care, where the proof of the lack of action is sufficient. It's sufficient to prove that that person did not act, did not make any action to prevent the damage to occur, and then the breach of the duty of care is established. So, is that clear? How this articulate together? First of all, that person has acted but negligently. Second possibility, that person has not acted at all, has made no positive action, and the damage is due to the fact that that person has made no action to prevent the damage to occur. In this second shape of negligence, as a general principle, there is no general duty imposed on the person to act to prevent the damage, except in the 4 particular circumstances settled by case law. So the defendant has to take care, has to take reasonable care to avoid any injury suffered by the plaintiff, and the standard of care is the one of the reasonable person, the reasonable man, but this standard is assessed with particularity, and the situation and the facts of the case are of great importance in the determination of the existence of a breach of a duty of care. Indeed, the notion of reasonable care varies according to circumstances, and also according to the notion of risk. High risk implies great care. It seems to be obvious, but indeed case law has made some moderation in the appreciation of the reasonable care, depending on the nature of the activity the party were involved in. If the activity is a risky activity, the standard of care is higher than an activity that is very common or trivial or without any particular danger. So high risk in the activity that is that has been entered into by the party implies high standard of care. In addition, case law analyzes the likelihood of the damage in assessing the existence or not of a breach of a duty of care. So additionally, courts scrutinize the likelihood of the damage, what is called the remoteness. The remoteness of the damage, the fact that the damage, although foreseeable, is rare. Indeed, it can be anticipated that such damage will occur. That means that's the foundation of the duty of care. This could happen. It's foreseeable. However, it is very rare that this happens. Therefore, the court, in the determination of the breach of the duty of care, is that person behave carefully, with reasonable care. The court will consider if the foreseeable damage is frequent or is too remote to consider that that person has acted unreasonably. And the leading case on remoteness is the Bolton and Stone case. The facts were concerning the negligence of a cricket club. So you know the game, the cricket, very British. The liability of a cricket club was challenged because a cricket player hitting the ball made the ball pass off the protective fence, so beyond the playground. The ball passed the protective fence. The player has hit the ball so strong that the ball passed the protective fence and hurt the person who was passing by. So I don't know if you have had in your hand a cricket ball. I had, and I can tell you, it can badly hurt. It's really, it could be a dangerous thing, a cricket ball. And then that person was injured and challenged the liability of the cricket club that organized the cricket match that day. And indeed, the court considered that the cricket club has a duty of care regarding the person who were passing by the cricket playground. Indeed, that's, the duty of care is obvious. They are in charge of the security of course, the person in the playground, but also the person who are around. But nevertheless, it was clearly established in that case that the fact that one player managed to hit the ball so strongly that the ball passed the protective fences of the playground, it was proved that it has happened only 6 times in 30 years. So it's possible, but it's extremely rare. 6 times, considering all the cricket match that have been organized in 30 years. Therefore, the court considered that indeed there was a breach, there was a duty of care, but the damage was too remote. There was no breach of the duty of care. The cricket club is not liable for the damage suffered by that person. There was no way for the cricket club to prevent that player to refrain to hit the ball because of security reasons. He has taken a reasonable care in organizing the cricket match as it has done. So the damage, although foreseeable, and indeed a duty of care was established, was too remote in order for the court to consider that the cricket club is liable. Lord Porter held that it is not enough that there is a remote possibility that the injury may occur. The question is, would a reasonable man anticipate it? Would that cricket player have anticipated the fact that hitting the ball that strong, it would hurt somebody else? Since it happened only 6 times in 30 years, it was not unreasonable not to think about that. So the breach of the duty of care was not established. The court refused to consider any breach in that case. On the issue of anticipation, but I hope I'm clear on this point, the anticipation of the damage here is assessed not to determine the existence of a duty of care, but the breach of the duty of care. This element is not discussed so as to challenge the existence of duty of care. The duty of care is existing, there is no difficulty, but to challenge the existence of a breach of the duty of care. And another leading case is the overseas tankship case, that is also called the Vegan Mount case. Indeed, the notion of anticipation of the damage is assessed, is discussed in that case, so as to know whether the seamen who were on the Vegan Mount ship has taken appropriate precaution to prevent oil to overflow to overflow from the boat. That's what occurred. That ship was not that far from Sydney, the port of Sydney in Australia. And because of carelessness of the seamen of the Vegan Mount, some oil overflowed from the boat, and that oil gently reached Sydney Harbour, Sydney port, where some vessels, three vessels, were undergoing reparation. And because of the work of the person who were repairing and the three ships on the port, the oil set alight, and it was expensive damage was caused to the vessels who were undergoing reparation. And it was discussed in that case the fact that it could not have been anticipated by the seamen on the Vegan Mount that the oil that overflowed from the boat would reach Sydney Harbour, and that this oil will set alight because there was some work that was done on this place to repair boats there. Therefore, it was challenged, the breach of the duty of care was challenged on this point, the remoteness of the damage. It is very rare that this can happen. The court refused to consider that and really analyzed strictly the notion of anticipation, and considered that the damage in that case was not too remote. This could have been anticipated. Indeed, where oil overflowed from a boat, the oil will reach something, which will reach the coast or another. And when oil reaches the coast, damage could happen. That can be here material damage, but that could be another damage, ecological damage or whatever. So the court considered that the damage was not too remote, and that the seamen on the Vegan Mount could have anticipated the fact that the oil overflowed the boat will cause a damage. So the notion of risk I mentioned is taken into account, and the remoteness of the damage is scrutinized by the court in order to decide whether or not a breach of the duty of care can be proved. Regarding this particular point, the point of breach of the duty of care, precedent has very little value. I've mentioned that in the creation of a duty of care, or in the existence of a duty of care, precedent has a strong value. Precedent will rule any other identical facts. Considering the breach of the duty of care, precedent has very little value. It's really connected to the facts of a particular case, so as to know whether or not that person is in breach of his or her duty. case law is rooted on fact, and it's not possible to infer from one case that in the same circumstances in the future there would be no breach, or there will be a breach of the duty of care held by the court. So on the analysis of the breach of the duty of care, case law has little value, and the facts are decided considering the really particular facts of the case. The conduct of the defendant in one particular case is appreciated. So I mentioned the fact that the standard of care is the one of the reasonable man, and the standard of care is appreciated also considering particular element. I mentioned the context and the circumstances. The reasonable man is the one that is placed in the same circumstances than the defendant. So I've mentioned that. The circumstances of the case are very important. The conduct of the tortfeasor will be analyzed regarding the standard of a reasonable man that is placed in the exact same circumstances than the tortfeasor. Therefore, the standard may vary from one case to another. The court will also have a look to the skills of the defendant. So the circumstances may change the solution. The circumstances I've mentioned may change the solution, but also the skills of the defendant are scrutinized by the court. And the standard of care that applies for one particular act varies depending on the fact that the person who made the act was used to do that, he was a professional, or he was doing the same act for the first time, for example. So the skills of the defendants are assessed by the court in order to determine if that person has breached his duty of care or not. And the standard of care that applies to a professional with particular skills, with specific expertise, is higher than the standard that is applicable to one person who is doing this action or is behaving like that for the first time, or for non-professional on a non-professional basis. And there is important cases related to medical liability. Medical liability has been treated in many cases, and a lot of case law on the issue of skills of the defendant, and this notion how the court analyzes the skills of the defendant. A lot of cases on this issue are medical law issues. And in the Bolen case, the court considered that where the court considered that the care or the standard of care must be analyzed regarding the common medical practice on this issue. So where the person is particularly skilled, is a medical practitioner, the standard of care he has applied regarding his or her patient is assessed regarding the common medical practice of same professional, other doctor of the same specialty, let's say. In that case, the patient suffered fractures, bones fractures, after an electroconvulsive treatment. So that person suffered different fractures after having undertaken an electroconvulsive treatment, after having taken some relaxant drug, in order to make the treatment, let's say, less painful. The doctor has given to the patient a relaxant treatment, kind of sedative treatment, but it was challenged that the fact to take this sedative increased the risk of suffering fracture after such electroconvulsive treatment. And the court had to assess whether or not it was common medical practice to give these particular drugs and sedative relaxant drug before undertaking electroconvulsive treatment. And the court considered that it was indeed common practice to do so, and that the risk of suffering fracture in taking these drugs amounted to 1 out to 10,000. So the risk was 1 out to 10,000, and it was a common medical opinion to support the use of this relaxant drug in this kind of treatment. Therefore, the court considered that since the medical decision was supported by a common medical practice, a body of opinion amongst medical practitioners, there was no breach in the duty of care. But this position was considered as overprotective for medical practitioners, because some academics pointed out the fact that it was pretty easy to find common medical practice, or at least groups of medical practitioners that are supporting kind of particular protocol or way of doing things. So this position settled in the Bolam case was analyzed as being too protective, overprotective on medical practitioners, and this position was specified in the subsequent case law. So I will discuss the subsequent cases after the break. So you take 10 minutes and I will go on this issue later.